Start para. These revision applications are filed challenging the judgment and decree dated 8 September 2022 passed by the appellate bench of the Small Causes Court allowing (A1) appeal number 107 of 2012 filed by the respondent defendant and setting aside the eviction decree dated 30 July 2012 passed by the Small Causes Court in RAE and R suit number 1146/1829 of 2003. The Small Causes Court had decreed the suit on the grounds of default in payment of rent and bona fide requirement while rejecting the ground of erecting permanent structure without landlord's consent and unlawful subletting. In the appeal filed by the tenant before the appellate bench, plaintiff landlord filed cross objections para. The appellate bench has allowed the tenant's appeal and has set aside the eviction decree by answering the grounds of default in payment of rent and bona fide requirement in favor of the tenant. The cross objections filed by the plaintiff landlord about rejection of grounds of putting up permanent structure and unlawful subletting are rejected, agreed by the judgment and decree dated 8 September 2022 passed by the appellate bench allowing appeal number 107 of 2012, civil revision application number 163 of 2023 is filed. Plaintiffs have also filed separate civil revision application number 164 of 2023 to the extent of rejection of their cross objections. Original plaintiff Bhaskar Barve was the owner of the structure situated on plot of land bearing number 12A Anand Nagar, Chembur, Mumbai. Shop number 2 in the said structure at measuring 150 square feet is the suit premises which was let out to defendant's father by tenancy agreement dated 19th April 1976. Under the agreement, monthly rent was agreed at rupees 100 and according to the plaintiffs, additional amount of rupees 100 was payable for use of furniture and fixtures. The tenant carried on business of kirana stores from the suit premises, and after the death of the original tenant, his son defendant started business of making chalks used in tubelight fittings. Plaintiff served notice dated 13th May 1997 to 1 Janubai alleging non-payment of rent since March 1996 and referring to Clause 11 of the tenancy agreement. Plaintiff terminated the tenancy and called upon the addressee to hand over possession of the suit premises. Landlord, however, did not initiate any steps in pursuance of that notice para. Since plaintiff was not recognizing defendant as tenant, he filed RAD suit number 120/1999 against plaintiff seeking declaration of tenancy. In that suit, a notice was taken out for deposit of rent in the court. After hearing both the sides, the notice was made absolute by order dated 3 July 2000, under which defendant deposited the rent in respect of the suit premises at the rate of rupees 100 per month and continued to depositing the same. After considering the overall conspectus of the case, I am of the view that the findings recorded by the appellate bench do not suffer from any jurisdictional error or material irregularity so as to warrant exercise of revisionary jurisdiction by this court under section 115 of the Code of Civil Procedure. Revision applications being devoid of merits are accordingly dismissed. Stop.